Hello everyone, hope you have an amazing day and welcome to my new blog. So today our topic is what is the Safety, Health and Welfare at Work Act 2005. The Safety, Health and Welfare at Work Act 2005 which repealed and replaced the Safety, Health and Welfare at Work Act 1989 was brought in to make further provision for the safety, health, and welfare of persons at work. This act clarifies and enhances the responsibilities of employers, the self-employed, employees, and various other parties in relation to safety and health at work. The Act also details the role and functions of the Health and Safety Authority, provides for a range of enforcement measures that may be applied, and specifies penalties that may be applied for breach of occupational safety and health also. So, what does the Act replies to? And what are my duties as an employer under the 2005 Act? Now we discuss in details later. First of all, we discuss about the Act. So, to ensure the safety and prevention of risks arising from the use of the articles or a substance or the exposures to noise, vibrations, radiations, or any other housing agents, to provide systems to work that are planned, organized, performed, maintained, and revised and as appropriate so as to be safe and risk free. So to provide the and maintain facilities and agreements for the welfare of the employees at work, to provide information in instruction, training, and supervisions also where necessary, to implement the safety, health, and welfare measures necessary for protection of employees as identifies through risk assessment, and ensuring that these measures take account of changing circumstances and the general principle of prevention specified in Schedule 3, to provide protective clothing and equipment where risks cannot be eliminated or adequately controlled, to prepare and revise emergency plans and procedures also, to report accidents and dangerous occurrence to the relevant authority prescribed under section 33, to obtain where necessary the service of a competent persons for the purpose of ensuring safety and wealth at work, to ensure that all safety measures take into account both fixed terms and temporary works, and that any measures taken do not involve financial cost to his or her employees. Now, informations to employees part 2 section 9 include when giving informations to employees, employers must ensure that it is given in such appropriate form, manner, and language that it is likely to be understood by the employees concerned. Ensure that the information includes the workplace hazards and risks identified, the protective and preventive measures taken, and the name of the safety representatives and all other persons also in the evacuations procedure, etc., where persons from other employment are engaged in work activities in an employer's undertaking. The employer must ensure that the person's employer receive the above informations. The employer must ensure that the safety representative section number 25 and designated competent persons section 18 have access to the risk assessment informations relating to reportable incidents and accidents, also informations arising from protective or preventive measures. The employer must provide information relating to the following before a fixed term or temporary employee commence work: any potential risk, health surveillance, any special occupational qualifications or skill required, any increased specified risks which the work may involve, the instructions, training, and supervisions of employees, Part 2, Section number 10. The employer must ensure that all instructions, training, and supervisions is provided in a manner, form of language that is reasonably likely to be understood. Now, employees receive during time off from their work without loss of pay, adequate health, safety, and welfare training also, including in particular information and instructions relating to the specific task to be performed and measures to be taken in an emergency. The employees' capabilities in relations to safety, and welfare, health and welfare are taken into account also. In the case of a class or classes of sensitive employees or groups of employees to exposed to risk expressly provided for in the relevant statutory provisions. The employees are protected against the danger that specifically affect them, and training must be adapted to take account of new or changed risk in the workplace. Training must be provided on recruitment when an employee is transferred or task changes, on the introductions of new or changed work equipment or work system, also on the introductions of new technology. All contractors etc. carrying out work in an employer's premises that receive relevant safety instruction also. And emergencies and serious and imminent dangers, Part 2, Section 11, the employer must provide adequate plans and procedures to be followed and measures to be taken in the case of emergency or serious and imminent danger. In organizations, these plans should provide measures for first aid, firefighting, and premises evacuations taking into account of the nature of the work being carried out and the size of the place of work also. Arrange necessary contracts with appropriate emergency services, first aid, emergency, medical care, rescue, and work and firefighting also. Designate employee who are required to implement these plans, procedures, etc. Ensure that all designated employees have adequate training and equipment available to them. In the event of an emergency or serious imminent danger of, employer must inform all the employees of the risks and steps taken to protect them, refrain from requiring employees to carry out or rescue work where there is still a threat to their safety, ensure that in the absence of appropriate guidance or instructions based on the employee's knowledge and technical means at his or her disposal, the employees must take appropriate steps to avoid the consequences of the danger, take actions and give instructions for employees to stop work and remove themselves to be a safe place. Ensure that an employee who leaves the place of work in the case of emergency is not penalized because of such actions. Ensure that access of specifically hazardous areas is restricted only to employees who have received appropriate training. Now, protective and preventive measures, Part 3, Section 18. The employer must appoint an adequate number of competent persons to perform the functions relating to protection of employees and give them adequate time and mean to perform these functions. Also, make arrangements for cooperations between the competent persons and the safety representative also. Give preference to competent persons within their employment when appointing a competent person. Hazardous identifications and risk assessment, Part 3, Section 19. The employer must identify all hazards in the workplace, keep a written assessment of the risks associated with each hazardous known as a risk assessment, and review the risk assessment if there is a significant change to the matter it relate to, or there is any other reason to believe that it is no longer valid. Implement any control measures or improvements which are identified by the risk assessment. Safety statements, part 3, section number 20. Employers must have an written safety statements based on the hazardous identification and risk assessment carried out, which specifies how they are going to manage and secure the safety, health, and welfare of the all employees at work. The safety statement should specify the uh, hazards identified and risk assessed, the protective and preventive measures taken, and the resources provided also. The emergency plans and procedures, the duty of the employees, the name of the job titles and the position of any assigned with safety responsibilities. The safety statement should be brought to the attention of employees at least annually or when there is any changes. Newly recruited employees upon the commencement of employment, other persons at the place of work who may be exposed to any specific risk. The employer must review the safety statement if there is a significant change to the matters it relates to. There is any other reasons to believe that it is no longer valid. Inspector directs the statements to be amendment. Every employer must ensure that all contractors providing services to the employer have an up-to-date safety statements. Also, the copy of the safety statements is kept available for inspections at or near place of work. If an employer who employs 3 or fewer employees is engaged in an activity for which there is a code of practice for that type of activity, they can fulfill their duty in relations to safety statements also by complying with such code of practice. Duties of employer to cooperate, part 3, sections 21. Where employer share a place of work, they must cooperate in complying with and implementations the relevant statutory provisions, coordinate their actions in relations to preventions and protections of employees, inform each other respective employees safety and representative etc of all risk, and including the exchange of safety statements and relevant extracts relating of hazards and risk. Health surveillance and medical fitness to work, part number 3, sections 22 and 23. Employer are required to ensure that health surveillance appropriate to the risk and that may be incurred in the place of work is available to all employees. The Act requires an assessment of medical fitness or to work of employees involved in certain work activities or occupations. So these activities and occupations will be detailed in regulations. Employees are required to inform their employer or their employer's registered medical practitioner if they are unfit to carry out a prescribed work activity. If an employer is notified of the unfitness of the employee, they must immediately take appropriate actions to comply with the general duties of employers to ensure the safety, health, and welfare of all employees at work. Now, safety representative, part 4, section 25. Agree with the safety representative the frequency of the inspections to take place. Consider any representations made to him or her by the safety representative, and so far as reasonably practicable, take any actions that he or she considers necessary or appropriate with regard to these representations. Allow the safety representative such time off from their work without loss of pay as is responsible to ensure the safety representative to acquire the knowledge and training and time to discharge their functions also. Inform the safety representatives when an inspection is taken place. Give the safety representative a copy of the written confirmations and required under the act and send to the inspector that an improvement or prohibitions notice has been complied with, and consultations and participation with the employees. Part 4 section 26. Employers are required to consult with employees for the purpose of making them maintenance safety agreements or arrangements. Consult with their employees and safety representatives in good time regards protective measures proposed, the designations of employees with safety responsibilities, activities arising from or relating to the protections from and the prevention of risk, hazards, identification, risk assessment, the safety statements, the informations to be provided to employees as outlined above, the information, the planning and organizations of new technologies, particularly in relations to the choice of equipment, working conditions, and work environment. Now, penalizations, part 4, section 27. Employers are prohibited from the penalizations defined as dismissal, demotions, transfer, impositions of duties, or intimidations or threatening to penalize employees who are perform and duty exercising right or who may make any complaints relating to safety and health or who give evidence in reinforcement proceedings. So the dismissals or penalizations in such manner can be deemed to be an unfair dismissals within the meaning of the Unfair Dismissals Act of 1997 and 2001, and employees may also complain to the rights commissioners that their employer has penalized him for exercising their rights under the safety and health legislations. So that's for the end of the video, my friends. If you like my channel, please subscribe my channels and also share, like, comment on my channel. Thanks a lot for watching my video.